during the trial as a whole as required by the authority of Ketio Kali and others versus Republic, 1965 EA 555, and also considered the submissions made by both the prosecution and the defense. Counts numbers 1, 2, and 3 herein are closely interrelated, and therefore I will consider them side by side. The 3 counts are similar, are of similar charge, and point for determination with regard to each of the 3 counts is whether the prosecution has proved beyond reasonable doubt that the accused persons or any one of them committed the alleged offense of robbery with violence, contrary to section 296, subsection 2 of the Penal Code as alleged in the particulars of offense to each of the said counts. From the evidence on record, particularly the evidence of PW1 and PW2, there is indication that at the material time of the alleged incident to which count number 1 relates, motor vehicle registration number KBF 796A Nissan Sunny Beige color was registered in the name of PW2, and at the material time was being driven by PW1. From the evidence of the said 2 witnesses, PW1 bought the motor vehicle and had it registered in the name of PW2, who was his wife. On the material day, the 2 were together, and as PW2 went to buy vegetables and groceries, PW1 remained in the vehicle where it was parked, where a group of 4 men entered the vehicle after one of them, who was armed with a rifle, ordered him to open the door and ordered him to go to the back seat. One of those people drove the vehicle, and he described in his testimony, summarized in detail in this judgment here in above, and took away his mobile phone, make Nokia and Huawei, and also gas cylinder that was in the vehicle. The said vehicle, from the evidence of PW6, was the one that was used to intercept the motor vehicle registration number KBE 464L, where PW3 and PW4 were, and were ordered to move to the rear, and were robbed and eventually abandoned at the home of PW8 on the same night of the incident. PW6 witnessed the incident, and then PW7 was notified and proceeded to the scene, where he found the vehicle registration number KBF 796A abandoned at the gate, and inside the motor vehicle they found PW1 inside the boot, and then PW1 narrated what had transpired. PW18 also arrived at that scene and found PW1 already rescued from the boot of the vehicle. From the evidence of PW1, PW3, and PW4, 4 people robbed PW1. And again, from the evidence of PW3 and PW4, the latter 2 were also robbed by 4 people. Robberies were preceded by carjacking of respective vehicles in which the respective victims were, and victims eventually abandoned. While PW1 was abandoned while inside the boot of the car registration number KBF 796A, from which the robbers came from, and hijacked the car in which PW3 and PW4 were. PW3 and PW4, after being robbed, were abandoned near the homestead of PW8 and sought refuge at the home of PW8 after the robbers drove off. The robberies took place, from the evidence on record, as part of the same transaction. There were 4 robbers in each of the incidents. From the evidence of the victims who testified as PW1, PW3, and PW4, one of the robbers had a big gun. The big gun was identified in the course of the trial and produced as prosecution exhibit number 3. PW4 testified that the person who had the gun was the first accused person hearing. From the evidence of PW1, PW3, and PW5 in relation to identification at the identification parade. The evidence of PW1 was that he did identify the second accused. PW3 identified the second, the third, and the fourth accused persons. PW4 identified the first, the second, and the fourth accused persons. And PW1 and PW3 also stated on cross-examination that they were not asked at the time of reporting the incidents to give description of the robbers. I will come back to this in the course of this statement. The evidence of PW4 was that the first accused is the one who had the big gun during the robbery incident. The testimony of PW4 was that by the time she jumped to the back seat as ordered, the fourth accused was already in the vehicle seated on the back seat and is the one who asked her for her phone. Each of those victims described in their testimonies as summarized herein above the words which the assailants uttered, which they asked them to utter during the identification parades. The respective identification parade forms wherein the said PW1, PW3, and PW4 participated as witnesses were produced as prosecution exhibits 1, 6, and 8. The evidence of PW6, who conducted the identification parades, where PW1, PW3, and PW4 participated as witnesses, was in tandem with the testimonies of those witnesses with regard to conduct of the parades. PW19 conducted identification parades where the third accused was identified by PW3, while PW1 was not able to identify anyone in the parade he participated as witness. And PW19 produced the parade form in that regard as prosecution exhibit 5. PW19 also conducted identification parade for the first accused, wherein PW4 participated as a witness. It stated PW4 identified the first accused person hearing, and it produced the parade form as prosecution exhibit number 8. The evidence of PW19 is also consistent with the testimony of PW1 and PW4 with regard to the identification parades. The first accused person stated that he took part in the identification parade and that he was not identified and he could not have signed the parade form because he had an injury on his hand, which he sustained during his arrest. And the second, third, fourth, and fourth accused persons denied having taken part in any identification parade. I have perused the testimonies of the said accused persons and noticed that the testimonies are majorly focused on absolute denial, to an extent that the testimonies of each of the said first, second, third, and fourth accused persons have internal inconsistencies, which calls for careful weighing of the same alongside other evidence on record as a whole as required. The court is guided by the decision of superior courts with regard to how inconsistencies in evidence are to be treated in a criminal trial, one of which is the case of Patrick Analo and another versus the Republic 2019, Kika 162 KNR, where the Court of Appeal stated as follows, and I quote, "In John Nyagajuki and 4 others versus Republic, this court explained the law on contradictions and inconsistencies in evidence as follows, quote, in certain criminal cases, particularly those which involve many witnesses, discrepancies are in many instances inevitable. But what is important is whether the discrepancies are of such a nature as will create a doubt as to the guilt of the accused. If so, then the prosecution would not have discharged burden squarely on it to prove the case beyond any reasonable doubt. However, where discrepancies in the evidence do not affect an otherwise proved case against an accused, a court is entitled to overlook those discrepancies and proceed to convict the accused. The discrepancies in the evidence in the matter before us are, in our view, of a minor nature, considering the facts in circumstances of the case. End of quote. Also, in the case of Twaigani Alfred versus Uganda, Criminal Appeal number 139 of 2001-2003 UGCA, it says, it was stated as follows, open quote, with regard to contradictions in the prosecution's case, the law as set out in numerous authorities is that grave contradictions, unless satisfactorily explained, will usually, but not necessarily, lead to the evidence of a witness being rejected. The court will ignore minor contradictions unless the court thinks that they point to deliberate untruthfulness, and if they do not reflect the main substance of the prosecution's case. Unquote. The testimonies of PW1, PW3, and PW4 with regard to identification evidence is consistent with the testimonies of PW16 and PW19, who conducted identification parades. A careful perusal of the evidence on record reveals that these witnesses were quite consistent in their narration of events that took place during the material night. During the incidents of robbery, the persons who robbed them were not previously known to any of them. From the evidence on record, the witnesses each asked those in the parade to utter specific words which they stated they uttered during respective robberies, and it was based on the utterances of such words that they were able to identify the suspects in the respective parade. This was therefore a case of voice identification. The words from the evidence of PW16 and PW7 and PW19 were given by the witnesses to those officers who conducted the respective parades, and the witnesses indicated to those officers they could be able to identify the suspects upon uttering the words. From the evidence on record, as summarized herein, those identified were so identified upon uttering specific words, had it been an identification solely on physical appearance, the witnesses would have been expected to have beforehand given description of the assailants. That would be in line with the decision of the Court of Appeal in the case of Victor Mwenda Ulinge vs. Republic, 2014 Kika at 710, where the Court of Appeal said, open quote, Ajode vs. Republic. In Ajode vs. Republic, this court held that before an identification parade is held, a witness should be asked to give description of persons sought to be identified. Ideally, that advanced description of a person ought to be in writing, and the same, together with the parade forms, availed to the trial court so that it can compare the description given of the accused. Unquote. With regard to identification by voice, in the case of Choge vs. Republic, 1985 KLR, it was stated, quote, evidence of voice identification is receivable and admissible in evidence, and it can, depending on the circumstances, carry as much weight as visual identification. In receiving such evidence, care would be necessary to ensure that it was the accused person's voice, that the witness was familiar with it and recognized it, and that the conditions obtaining at the time it was made were such that there was no mistake in testifying to that which was said and who had said it. The robbery incidents took place on the night of 6th and 9th of February 2015. Identification parades were conducted on 15th February 2015. After about 8 days from the date of the said robberies, memories would not fade in about a week. And from the evidence on record, the robberies were in the vehicle where the victims who had been carjacked were for some time during the night. They were talking, and all the witnesses were interested in the specific words which were spoken specifically, commands they received during the incidences. From the evidence adduced, by the victims who testified as PW1, PW2, and PW4, in each of the PW1, PW3, and PW4, in each of the robbery incidents, the robbers were 4 men, and they respectively described in their testimonies how those 4 men entered the respective vehicles. From the evidence of PW22, PW30, and PW31, who were part of the team involved in the arrests, the female suspects came in at the point of arrests. The 5th and the 6th accused persons, from the evidence on record, were arrested on the same day the other accused persons were arrested. And from the evidence on record, the 5th and 6th accused persons are not sufficiently linked to the robberies, and none of the said 5th and 6th accused persons herein is neither principal offender within the meaning of Section 20 of the Penal Code, nor a joint offender within the meaning of Section 21 of the Penal Code. With regard to the 7th accused, no identification parade was conducted wherein he was lined up as a suspect. There is no evidence that he was spotted anywhere within the vicinity of the robberies that took place on the material night. From the evidence of PW14, PW15, PW30, and the testimony of the 7th accused person, the 7th accused used to charge funds for other people in his house. He had known the 5th accused person for 3 years, and the 5th accused person introduced to him the 3rd accused person as a husband, and he stated that the 3rd accused is the one who gave him the phone to charge. That was the morning of 7th February 2015, a day following the night of the robberies, which took place on the night of 6th and 7th of February 2015. The testimony of the 5th accused person is in tandem with the testimonies of PW14 and PW15, which corroborate the same, and his testimony is consistent with what he told the police at the time of his arrest, which is also corroborated by the testimonies of PW14 and PW15. On the issue of accomplice evidence, the Court of Appeal had this to say in the case of John Karunji Mberire versus Republic, 2015, Kika at 107, and I quote, on the issue of accomplice evidence, which the appellant contends was improperly acted upon, this court in Stephen Kelang, Mahalale, and another versus Republic, 2010 EKR observed, open quotes, the position in law with regard to accomplice is this. An accomplice is a competent witness against an accused person. However, such evidence needs corroboration. In the case of Uganda versus Shah, the Court of Appeal for East Africa, in dealing with the question of accomplice evidence, rendered itself as follows, to quote, the second and third grounds of appeal were that the learned judge had erred in holding that there was no independent evidence incriminating either the first or third respondent, corroborating the accomplice evidence against him. The facts relied on by the prosecution were finding of 113.5 bags of Arabica coffee on the Kiriri estate where only Robusta was grown, and the expert evidence was that the coffee was found similar in quantity of the stolen coffee. The learned magistrate held that these facts were capable of amounting to corroboration. Evidence to be corroborated must be independent, and it must implicate or tend to implicate the individual accused of the offense. It is clear from that authority that accomplice evidence is admissible, and also that if believed, it might be relied upon to found a conviction if corroborated by independent and admissible evidence. End of quote. It is also in evidence adduced during the trial that the 7th accused person is the one who led to the arrest of the 3rd accused person at the time of arrest. Sorry, let me read again. It is also in evidence adduced during the trial that the 7th accused person is the one who led to the arrest of the 3rd accused person, who at the time of arrest was in the company of 4th accused person, who then led to the arrest of the first accused and the sixth accused person, and recoveries were made during the arrest. Can that fact that the fourth accused person led to the arrest of the other accused persons, and the fact that recoveries made during those arrests be used against the fourth accused person hearing? The Court of Appeal in the case of Ahmad Abolafadi Mohammed and another versus Republic 2018 Kika at 7:43 held, and I quote, when Karukenya and four others versus Republic was decided in July 1984, Section 31 of the Evidence Act expressly allowed admissibility of evidence discovered in consequence of information given by an accused person, whether the giving of the information amounted to a confession or not. The provision, whose side note read information from accused leading to discovery of facts provided thus, quote, notwithstanding the provisions of sections 26, 28, and 29 of this Act, when any fact is deposed as to discovered in consequence of information received from a person accused of any offense, so much of such information, whether it amounts to a confession or not, as relates distinctly to the fact thereby discovered, may be proved. However, in 2003, the Criminal Law Amendment Act number 5 of 2003 affected fundamental changes as to the law on confessions and admissibility of information from an accused person, leading to discovery of evidence. Among the changes, a new section 25A was introduced into the Evidence Act, which made confessions inadmissible unless made in court. In addition, Section 103 of the 2003 Act repealed Section 31 of the Evidence Act, meaning that henceforth information from an accused person leading to discovery of evidence was not admissible. As this court noted in Toya, Kitsao, Alliance Katibu versus Republic 2015, EKR, those changes were intended to address the then egregious abuses and irregularities arising from confessions taken by the police. Practical challenges in the implementation of the new law, however, led to further amendments in 2017 through Statute Law Miscellaneous Amendment Act number 7 of 2007, which allowed confessions to be made before a judge, a magistrate, or a police officer, other than the investigating officer, being an officer not below the rank of Chief Inspector of Police, and a third party of the suspect's choice. It also allowed the Attorney General, in consultation with the Law Society of Kenya, the Kenya National Commission on Human Rights, and other suitable bodies, to make rules governing the taking of extrajudicial confessions, leading to promulgation of evidence out of court confessions rules 2009. What is very clear in all this is that Section 31 of the Evidence Act, or a variation thereof, was not re-enacted, meaning that information from an accused person leading to discovery of evidence is inadmissible outside a confession. This was the position that this court took, for example, in Kennedy Otieno Oden versus Republic 2008 EKR. In this appeal, it was never the prosecution's case that the appellant had confessed to committing the offenses that they were charged with. Accordingly, we are satisfied that the two courts below erred in admitting the evidence that allegedly led to the discovery of the RDX. End of quotes. There is clear and consistent evidence that the third accused was in possession of phones stolen during robbery, escorted by the fifth accused person, and took the same to the seventh accused person to charge it for him. That is proved beyond reasonable doubt, even on the face of denials by the third and fifth accused persons. The Court of Appeal in the case of William Ougo Arunda, hitherto referred to as Patrick Odworo Ching versus Republic 2022 Kika at 23, had this to say with regard to the doctrine of recent possession, open quotes. We start with the question whether the doctrine of recent possession was properly invoked as regards the circumstances under which the doctrine of recent possession may apply. In Salim Athman vs. Republic 2016 EKR, the court held that, open quotes, the essence of the doctrine is that when an accused person is found in possession of recently stolen property, and is unable to offer any reasonable explanation as to how he came to be in possession of that property, presumption of fact arises that he is either the thief or receiver. The circumstances under which the doctrine will apply were considered in Isaac Ng'ang'a Kahiga, alias Peter Ng'ang'a Kahiga vs. Republic, criminal application number 272 of 2005, where the court stated, quote, "It is right that before a court of law can rely on the doctrine of recent possession as a basis of conviction in a criminal case, the possession must be positively proved. In other words, there must be positive proof, first, that the property was found with the suspect, secondly, that the property is positively the property of the complainant, thirdly, that the property was stolen from the complainant, and lastly, that the property was recently stolen from the complainant. The proof as to time, as has been stated over and over again, will depend on the easiness with which the stolen property can move from one to the other." End of quotes. The evidence of record, particularly the evidence of PW 14 and PW 15 and PW 30 and the seventh accused person, exonerates the seventh accused person and proves the doctrine of recent possession as against the third accused. In the William Oungo Arunda case quoted above, stolen property was found in possession of an appellant within hours of occurrence of incidents of theft, like is the case here, where the third accused was in possession of phones stolen from victims of robbery in the morning following the night of the robberies, and the Court of Appeal stated, and I quote, "As stated by the Supreme Court of Uganda in Bogere, Moses and another versus Uganda, Criminal Appeal number 1 of 1997, that, open quote, it ought to be realized that where evidence of recent possession of stolen property is proved beyond reasonable doubt, it raises a very strong presumption of participation in the stealing, so that if there is no innocent explanation of the possession, the evidence is even stronger and more dependable than eyewitness evidence of identification in a nocturnal event. This is especially so because inevitably the former is independently verifiable, while the latter solely depends on the credibility of the eyewitness." End of quote. On the material night of the robbery, from the evidence of PW 20, the third accused person sourced for services of PW 20, who operates a taxi, and he explained how the third accused guided him to where he picked other persons whom he dropped at respective places as directed. And then after dropping them, he realized that those people left a bad-smelling, N-shaped metal in the vehicle. The metal was later established to be part of a gun. A rifle recovered from the house where the first accused person and the sixth accused person were arrested that had L-shaped component missing from it. The evidence of PW4 was that during the incident on the material night, the first accused is the one who had the big gun, while the seventh accused person explained how the third accused in the company of the fifth accused person took to him phone for charging. There is no explanation from the third accused person how he came by the phone which had been robbed the previous night. The doctrine of recent possession shifts evidential burden once the prosecution has discharged the legal burden, as it has done in this case. And while there is no legal burden on the accused to prove innocence, there is nothing to displace application of the doctrine of recent possession. There is more than identification evidence against the first, second, third, and fourth accused persons hearing, insofar as the first, second, and third counts are concerned. There is also strong suspicion that the fifth and the sixth accused persons may have been passive members of the same gang, but suspicion, however strong, is not enough. Those who were robbed on the material night did not see any lady amongst the robbers. Neither did PW20, the taxi driver, carry any lady in his car on the material night. The seventh accused has been exonerated by his own evidence and the evidence of PW14, 15, and 30. And therefore, in my finding, the first, second, and third counts have been proved beyond reasonable doubt against the first, the second, the third, and fourth accused persons, and not proved beyond reasonable doubt against the fifth, sixth, and seventh accused persons hearing. Counts numbers 4 and 5 are also closely related, and therefore I will deal with them side by side. The point for determination with regard to the fourth count is whether the prosecution has proved beyond reasonable doubt that the first and the sixth accused persons hearing were unlawfully found in possession of firearm, namely G3 rifle, serial number KP 6927317 without firearm certificate. And the point for determination with regard to the fifth count is whether the prosecution has proved beyond reasonable doubt that the first and sixth accused persons were unlawfully found in possession of 7 rounds of 7.62mm caliber ammunition without a firearm certificate, as alleged in the particulars of offense to the said counts, numbers 4 and 5 respectively. The evidence of PW29 was that he is a police officer and was issued with the G3 rifle, serial number 6927317 on 22nd of October 2013, and the same was entered in the register as entry number 1041. He testified that he was robbed of the said rifle while on duty on the same day at night, where he was providing security to telecom personnel who were on duty. The evidence of PW22, PW30, PW31, and PW36 was that the first accused and the sixth accused at the time of their arrest were in the same house. The sixth accused person opened the door, and then the first accused was found in the house hiding under the bed. The first accused testified that he was not arrested in that house, and also stated that it is not true that the sixth accused person is the one who opened the door. If he was not there, how could he say that the sixth accused did not open the door? The sixth accused person also in a testimony denied. The evidence on record adduced by the prosecution is, however, to the effect that the recoveries made from the house at the time of arrest of the first and the sixth accused persons were documented in an inventory which was produced in evidence. The recoveries were also produced in evidence. PW11 and PW12 were the persons who left the house to the sixth accused person, and the landlord to the sixth accused person respectively. The recoveries from the evidence of record were submitted to ballistic expert for examination, and the evidence of the ballistic expert confirms that they are a firearm and ammunition respectively. While there is an inconsistency with regard to whether the bag where the gun was found was in the kitchen or the bathroom, it is a minor one expected to arise in a recovery made during such an operation, and this is taken care of by the authority of Maingani Alfred vs. Uganda, already cited here before. There is no evidence that any of the first or the sixth accused person had a license to hold either the firearm or the ammunition. And therefore, from the evidence on record, there is proof of counts numbers 4 and 5 against the first accused person and the sixth accused person beyond reasonable doubt. Equally, counts numbers 6 and 7 are also closely related, and therefore I will consider the same side by side. With regard to count number 6, the point for determination is whether the prosecution has proved beyond reasonable doubt that the second accused person herein was found in unlawful possession of Seska pistol, serial number G4726 without a firearm certificate. And the point for determination with regard to the 7th count is whether the prosecution has proved beyond reasonable doubt that the second accused was found in unlawful possession of 15 rounds of 9mm caliber ammunition without a firearm certificate. From the evidence on record, including the evidence of PW22, PW26, PW30, and PW36, a pistol serial number G4726 had been issued to a police officer who was the bodyguard to the deceased Honorable Muchai, as per the register produced as Prosecution Exhibit 28. And that firearm was recovered from the house where the second accused person was arrested, together with the rounds of ammunition in question. The evidence of record is that the same were forwarded to the examiner, who adduced evidence that he examined the same and found the same to be firearm and ammunition respectively. PW6 testified that he had rented the house to the second accused person hearing, who was using a different name, and that he came to know his real name after the arrest. The second accused testified that nothing was recovered from him and that he was not arrested in that house. The denial by the second accused is faced by credible evidence adduced by prosecution with regard to his arrest and recovery. The testimony that the police were out to arrest people so as to meet deadline of 72 hours. A deadline of 72 hours set by the then Minister for Interior would really not convince. Otherwise, some of those traced during investigations, like PW14 and PW15, would not have been witnesses. The evidence adduced by the prosecution proves that the second accused was arrested from the house in question, where the firearm and ammunition that are the subject of count number 6 and 7 were recovered. There is no evidence that the second accused person had the requisite certificate to hold the firearm and the ammunition, and I therefore find counts number 6 and 7 are falsely have been proved beyond reasonable doubt that is filed. With regard to count number 8, the point for determination is whether the fifth accused was found in unlawful possession of 2 rounds of 9mm ammunition without a firearm certificate, as alleged in the particulars of offense to count number 8 aforesaid. The fifth accused in her testimony stated that there was nothing recovered from her at the time of arrest. The evidence adduced by the prosecution is that in the house where the fifth accused was taken, there were 2 rounds of ammunition recovered and an inventory prepared and signed by those present, including the fifth accused person hearing. The said inventory was produced as Prosecution Exhibit number 33, and it is signed by the fifth accused. And the report of ballistic expert produced as Prosecution Exhibit 14 confirms the same as ammunition. There is no evidence adduced to show that the fifth accused was at the material time a holder of the requisite certificate, and I therefore find that the 8th count has been proved against the fifth accused beyond reasonable doubt as required. In summary, I make the following findings under Section 215 of the Criminal Procedure Code. A, the first, second, third, and fourth accused persons are each guilty of each of counts numbers 1, 2, and 3 herein before first mentioned, and each of the said first, second, third, and fourth accused persons is each convicted of each of the said first, second, and third counts. B, each of the fifth, sixth, and seventh accused persons is not guilty of each of the said counts numbers 1, 2, and 3, and is each acquitted of the said counts numbers 1, 2, and 3. C, the first and the sixth accused persons is each guilty of count numbers 4 and 5, and each of the said first and sixth accused persons is convicted of the said counts 4 and 5. D, the second accused is guilty of counts numbers 6 and 7 aforesaid, and is convicted of each of the said counts numbers 6 and 7. E, the fifth accused is guilty of count number 8, and is accordingly convicted of the said count number 8. The seventh accused person, who has been acquitted of all the 3 counts he is facing, is ordered to be set to liberty unless he is otherwise lawfully held. That is the end of the statement.
Much obliged, Your Honor.
So the judgment is typed. I was making corrections as I was reading typographical errors, which I'm going to correct, and by 4 p.m. we will have it online.